First of all, we are either lawyers here, law students, aspiring lawyers. So I think you'll understand that in addition to answering the question that you've posed, I'm going to twist your question to answer the question that I'd like to answer and then answer the question that you've asked. Let me make a couple of general points and then we'll move to your question. First of all, the appointment of a Supreme Court justice says as much about the president who is making the appointment as it does about the nominee, him or herself. I think in the instance of the Sotomayor nomination, this president has made a profound statement that excellence in background and experience and diversity in appointment can be achieved. Not only is it compatible, it's readily achievable. And that in the selection of Justice Sotomayor, Judge Sotomayor, this president has made a clear statement that moving forward, a country which purports to be the world's largest, most diverse representative democracy, has an obligation to try to achieve the balance between excellence in background and preparation and diversity of appointment. That's point number one. Number two, I think Judge Sotomayor's academic and professional background speaks eloquently for itself. And so I have no problem in those who would seek to examine her record, obviously her achievements at Princeton, her achievements at Yale Law School, her participation in the law review, speak eloquently of her background. Her trial experience, her term on the Court of Appeals, again, adds to that luster. Her role as a prosecutor with Prosecutor Morgenthau, again, all speaks eloquently to where we are. So I deeply resent the implicit double standard that is now being applied by some of her critics that seek to diminish her academic accomplishments and her professional background as they seek to elevate those provisions of controversy which I think have been wrongly cited. And then lastly, it does seem to me that hyperbole and histrionics have no place in this conversation. I think it does a profound disservice. It's not only an unseemly display of partisan rancor, it does a profound disservice to the significance of this debate. The use of personal invective, the elevation of terms like racism, and I'm speaking specifically now of people like Karl Rove, Newt Gingrich, Tom Tancredo, and others who have sought to diminish Judge Sotomayor's accomplishments by this kind of smokescreen of invective, need to be challenged on the issue, and they need to be asked to repudiate their positions. And I would simply say, look, quite simply, have you no decency? Have you no shame? I mean, is that still a term that can be used in the context of this discussion? Now, let me answer your question, okay? I would say first that there is a very simple definition of judicial activism. It's taken from Black's Law Dictionary. It defines it as a philosophy that motivates judges to depart from strict adherence to precedent or when a court steps on the role of other branches of government. But more precisely, I actually support the definition of Wendy Long of the Judicial Confirmation Network, who says the following: in our country, judges are the servants of a written constitution, the first one in history and now widely emulated, and the laws that we make through our elected representatives. This is the definition of self-government or government by consent of the governed. So in America, under the rule of law, judges are bound to apply neutrally the law that is written in the Constitution, Bill of Rights, and the laws enacted by the representative bodies of the people. I believe that as a point of philosophy to be true. Obviously, judges, and particularly on the highest court of the land, will apply those principles and interpret them, apply them to new circumstances which might deviate from established precedent. But I also believe that Christina is accurate. The term has been bandied about by both sides of the debate for so long that it has lost any real meaning. So you have to give it context. And for that, I look to a recent column by Norm Orenstein, someone who is a contributing scholar for Roll Call, who cites the North Austin Municipal Utility District voting rights case and the recent arguments that were held at the Supreme Court to give us a sense of what judicial activism from a conservative judicial perspective may mean. Now, obviously, the court will make the decision on that case, so I won't prejudge it. But certainly from the questions that were posed by Justices Scalia, Justice Roberts, Justice Alito, there seemed to be a complete dismissal of the rightful role of Congress in making a determination that a law which seeks to establish certain protections, in fact, has a basis in the Constitution for doing so, and with thousands of pages of documentation, represent the rightful role of Congress in making those decisions. Any deviation from that posture, it seems to me, does raise questions about judicial activism, and I think is a living example. And then empathy, I think, speaks for itself. One can look at a conventional dictionary, and it essentially translates into having the capacity to put oneself in the shoes of another. That is a human trait that we aspire to in evaluating the circumstances that we may confront on the part of others. Certainly that trait should be applied to judges as well. And so any judge who doesn't bring a sort of common sense value for the circumstances of others seems to me to have lost an important capacity to be effective as a jurist, and certainly being effective under new circumstances of today.